Is liberty dying where you live? Escape to Keene at freekeene.com.
Take some of these folks out. I need 7 seats over here for the city people to sit. Whoever wants to give up their seats. Sure.
Why would anyone have to give up their seats?
So that the city
Because
can
we're witnesses and
I
you're
have
not.
5 witnesses. No, he is, because he's one of the defendants.
He's one of the defendants.
I got 5 individuals that I need in the courtroom. I don't know if he's gonna do it up as a proof or however, but I got 5 individuals for that. Assistant city attorney can sit up here, and I have a paralegal. I could probably ask permission of the court to have him sit back here.
I'll talk
You
to
wanna
the
check
judge
with
and
the
see what he
judge?
wants to do.
Yeah, that'd be
Can we
good.
sequester those witnesses?
So, you let me know what's gonna happen, okay?
Okay.
With the people that are gonna be.
Are you all set?
I'm just trying to get out.
Get the mic.
It's over, yeah, it's where, I think it's where it's gonna need to be. I'll just double check with counsel.
Darryl, would you like a seat?
Well, we're going to be entering pretty soon, right?
So you're gonna sequester your witnesses? Okay. The judge isn't gonna make anybody move out. Bring somebody else.
Are we doing offers, or is he going to the?
I'm a little demoralized. I don't know.
Are you ready to set up?
Yep.
How about my paralegal?
You can bring her in. Yeah. Yep, go ahead. Who else is involved in this case? Not involved, but they'll be involved in it. Your name's on the list? 3 in front, 3 in back?
Let me get Leon in here.
Should be 6 people, right? Is that right?
Should be no people. No one's harassed anybody. I'm just paper on his hand.
Okay, so the only cameras that are allowed is Central, Channel 9, and if you're not allowed to, only Ian is
Yep,
authorized
you
to use
can't
the
run the
camera.
camera.
Why not?
That's
I'm
my
registered.
agent, and
Media,
it's
I
a
can show
registered.
you, this is the order,
Why?
I'm not going to discuss it, this is the order
Point
from
the
the
camera at
judge.
them, please, when
Okay.
they're talking to you.
Please sit down.
So you're saying that I'm not allowed to run this camera?
Would you please sit down?
Am I allowed to run this camera?
Would you please sit down?
Am I allowed to run this camera?
Bailiff says, Sheriff, can we have some deputies in courtroom 1, please?
Registered media.
You guys in the past, when we've had other people stand in when Ian's not been able to man his camera, I think it's pretty reasonable. But you're the one enforcing them, man. The rules don't matter unless people enforce them. These aren't rules, they're just made up to.
How is that supposed to report when he's on? I don't understand.
How's it possible to manage the camera and be up?
See, the thing is, Jason, both Darryl and I are registered media with the Supreme Court. We both have the same exact permission slip,
Yeah,
the
let me
same
tell
one
you,
these guys
let me
do.
tell you, you're the only one that filed.
I didn't file anything.
You
I
filed
don't
a
have
thing
to
for
file.
permission for the EA.
I don't have to file anything.
You did.
I filed with the Supreme Court
You
as a
filed.
registered media.
Right. But
So-
you're
Which is the
only
same
one-
form that I
I've
have.
only been told you're the only one. that
Well, you
can
need
run
to
the
check his
camera.
form then, because he's got one right
Why
there.
is the default to go on the attack instead of see if they're telling you the truth? If you're allegedly a
Why don't you
public
read what he's
servant, why don't
holding
you
out
look
there,
into
Bob?
it, man?
I'm not going,
See
it's
that,
up to
Bob?
the
He's got a
judge.
piece of paper for you, right there.
That's up to the judge.
Ridiculous, man.
So then why go on the offensive against him if it's up to somebody else? You just default to going on the offensive against these guys for no
We
reason,
don't, we
man.
don't make the rules, we just have to try to enforce them.
Right.
You're responsible for your actions, dude.
Why even think, right?
What if they told you to shoot anybody who talked to you in this room? Would you shoot me today? No, because you have a conscience and you know that's ridiculous. So why get on these guys for doing this, man?
This is an open public hearing.
You
We're
need
just
to-
making a record of
You need
it.
to call your dogs back, dude. You guys-
Smile for the cameras.
This whole thing is a charade, man.
Yep, sure is.
You guys are just upset that some money that you want to come in your coffers isn't being collected right now because people have found a peaceful tactic to deter that.
That sums it up. Here we go.
Okay, you can have one person from Free Keene operate a camera. Okay, no other electronic media, no recording, no videos.
And if you disobey, they'll put you in a cage.
I see a couple cameras up here filming us.
That's different.
It's different. Some hands and everything,
That's the security system.
Gee, the cups got small.
right? Hasn't kept me and my friends too secure this time.
Are we ready to start?
I know one of them has been dragged out of here.
You guys only let us have the video from that security system when you feel like it. Like when that guy set himself on fire, this is what this courthouse
I don't have anything to do with that.
all of a sudden that security video just disappeared.
I don't have anything to do with
Yeah.
that.
You have no moral qualm, you have no qualm with what happened? You didn't look in it? I know if I had a property and I had a business and someone burnt themselves alive outside, I'd be like, what the heck is going on? I wouldn't ignore it like nothing happened.
Just another day at court, ruining lives.
I guess that's what happens when your incentives are brought about through monopoly based on force. Playing force.
All right.
Thank you, please be
Stand up,
seated.
please.
Wait for the monitor.
There should be a seat over there.
The matter before the court is City of Keene versus James Cleveland, Garrett Ian, Kate Ager, is that how you pronounce it? Ager. And I apologize if I don't do it correctly. Ian Freeman, Graham Colson, Peter Iyer. Is it correct?
It really doesn't matter at this point, you know, I shouldn't even be here. So.
And if I could have counsel for the City of Keene identify himself.
Yes, Your Honor, Thomas Mullins, I'm the city attorney for Keene, and appearing with me is Leon Goodwin, who is the assistant city attorney.
Thank you. Just a preliminary matter. I believe we have answers from all parties, and there's just an issue regarding 3 of the answers. The answers for Ms. Ager, the answer for Mr. Cleveland, and the answer for Mr. Colson. Because of the signature on these, it's hard to tell whether these are actually signed by the people. So I'm going to hand these to the court officers, they can hand them to each of the defendants to sign them so that we can be sure that they are the actual answers of those people.
While you do that, there is also a couple of things I'd like to address.
Oh, yeah, no, we have some preliminary motions,
Okay.
Mr. Freeman, before we get started, and I'll move to those. I know there are some pending motions.
Your Honor, if I may, while we're waiting, it's a little unclear to me how the court is intending to proceed. Do we go on to office of proof, or are we going to
Graham Colson?
Well, preliminarily, Attorney Mullins, I'm going to address, Mr. Freeman had filed some motions.
Yes, I understand that.
And I want to first take up those motions before we address how we're going to proceed to the merits of the injunction.
Thank you.
Regarding your recent decision about the hearing.
Mr. Freeman, if you could just hold on a second, I want to take these up one at a time. I want to first make sure we have the answers before we move to the hearing. Let me state for the record that I now have signed answers from Mr. Colson, Mr. Cleveland, and Ms. Hager. And if I could just ask each of the defendants to stand and identify themselves for the record, one at a time, in whatever order you prefer, sir.
My name is Garrett Ian.
James Cleveland. Freeman.
Darryl Carlson.
8 acre.
I don't know, like, I'm Pete, I don't know what you guys, I'm not,
Sir, if you could stand when you're addressing the court.
well, thus far, this court hasn't earned my respect, so out of, just being straight up here.
I'm just gonna tell you right now that I'll give you and everybody an ample opportunity to address the court, ruling on these, and that is not an appropriate way to behave, but in terms of when people address the court, I'll allow you to say whatever you want to say, but going forward, if you have any arguments or issues you want to address with the court, you'll stand and address the court. Mr. Freeman, there are some pending motions that you filed, and the first is a motion to dismiss. So, Mr. Freeman, as I said, I'm going to take up those two motions to start, your motion to dismiss and your motion to extend the evidentiary hearing. I don't believe you filed any other motions. Are you aware of any, sir?
There was a motion to continue.
That's what I mean, your motion to extend the evidentiary hearing.
There was the extension and there was also continuance, because I felt like a half an hour probably wasn't going to be enough time for this particular hearing.
When did you file the motion to continue? Just want to make sure that I have a copy of it.
Filed on May 31st.
It's the one that you styled the motion to extend evidentiary hearing?
No, that's separate.
Okay, and Mr. Freeman, if you have, again, as...
I'll withdraw that motion. We're here today. We might as well, move forward, but I don't think...
Again, I'm just gonna tell you, if you have something, if you have arguments you want to make,
Oh,
you're gonna have to stand when you address the court.
So
So you're withdrawing your request to continue the hearing?
we're already here. We might as well move forward with that, but I do think that it's probably going to take more than a half an hour. We're already 11 minutes in.
I think you may well be right, Mr. Freeman. Let me say that there was also, as I understand it, Mr. Freeman, there was a request that you made for a sequestration order. Is that correct?
I don't know how my co-defendants feel about that. What is, I don't even know what that means. Would sequester the witnesses?
I'll explain. That's just an order that anybody who's going to be called as a witness, other than parties who are certainly permitted to remain in the courtroom, but any non-party witnesses who would be called would have to be out of the courtroom while other witnesses are testifying.
I would like that, yeah.
Yeah, I concur.
Again, if people want to address the court, I'm only going to hear you if you're standing.
I would concur in that we have not been provided a witness list. I don't believe.
So although Mr. Freeman has now withdrawn his request to continue the hearing, do any of the other defendants want the hearing to be continued? Okay, I take it the silence means that there's no longer a request to continue the hearing. Mr. Freeman, you separately moved for a dismissal in the case.
Yeah. Did you want me to make any points on that, or have you reviewed the file? I put in a response to the city's objection to that just the other day, which the city's objection didn't appear to actually address any of the points I made in my original motion, so I consider that to be non-responsive and frivolous.
If I may, Your Honor, I know you're being
I just want to give Mr. Freeman any other arguments you want to make in support of that motion?
Oh, yeah, well, certainly. I mean, since there's an audience here, I'd like to point out that according to various, court decisions, the court is limited to determining rights of persons or property which are controverted in a particular case before it. In evaluating whether a party has standing to sue, we focus on whether the plaintiff suffered a legal injury against which the law was designed to protect. From what I can tell, the plaintiff is not alleging that any of us have created any sort of injury in this case. There's no damage that has been alleged, so therefore there's nothing to go forward here. This is a complete waste of your time.
And ours.
Do any of the other defendants want to make further argument in support of that motion? Attorney Mullins.
Thank you, Your Honor. The initial motion that was filed, and I understand that there was an additional pleading that was filed, one that was filed on May 31 with respect to this apparent effort to dismiss. That motion was styled in the way of a standing issue, and I think a fair reading of the motion, despite what Mr. Freeman may be saying now, was that he was alleging there was no standing from the city's perspective with respect to the matter. The city certainly has standing here, as the court knows. We're a political subdivision of the state. The city draws all of its authority from the state. The state does provide the city with the authority and the power to enter into contracts. The underlying issue here, as the court is aware from reviewing the pleadings, is whether or not the defendants intentionally and tortiously interfered with that contract. As the matter progresses, the arguments that the city would make, or the evidence that the city would present, is that the city does have a contract. And we believe that the defendants are clearly aware of that contract. They're aware of the contract from the totality of the circumstances. These individuals wear our uniforms, they drive around in our city vehicles, and they do that sort of thing. So the underlying merit issue before the court is the allegation of a tortious interference with a contract. This is not about the money going into the parking meters. There's no allegation in the pleadings with respect for relief for money going into parking meters. There's no
Objection.
question.
My motion does not address the things he's even talking about here.
Again, Mr. Freeman, what I'll do is I'll give you a chance to respond to the arguments. I'd ask that you let the city finish, and then I'll certainly give you an opportunity, a fair opportunity to respond to their arguments. Attorney Mullins.
Thank you, Your Honor. My understanding is that you need sufficient factual basis to make a determination as to whether or not the city has standing under the underlying merit question that we're here on, which is intentional interference with contractual relationship.
Let me ask you a question about that. Do you believe if your claim for tortious interference with contract does not survive, if you haven't stated a claim for tortious interference with contract, do you separately, does your claim survive?
Well, Your Honor, as you know, for preliminary injunctive relief, there has to be a reasonable basis, not an absolute basis, for the court to determine whether or not the claim survives. At least on this hearing, where we're here now is on a preliminary basis. What the court has to make a determination on is to whether or not there may be some reasonable ability of the city to survive on the underlying merit question. I will submit to the court quite candidly that as far as we're aware, no court in the land has been asked to consider this cause of action within the context that it arises with these 6 defendants over here. There is no doubt about that.
And that's where I'm going with my analysis right off the bat. I wanted you to just, if you could, if I determine that separate and aside from the request for preliminary and permanent injunctive relief here, if I determine that you have not stated a claim for tortious interference with contract, does the case go away?
I'd have to say to the court that it does. The only basis for the preliminary injunctive relief is the question of whether or not the city faces irreparable harm from the possible loss of its parking enforcement officers as a result of the defendant's activities. So I think the answer to the court's question would be yes. There's no independent basis for injunctive relief if there's no underlying harm that the court can help correct. But I would say that, Your Honor, that we believe that the totality of the evidence before the court, and the court has to find that there's a reasonable basis. This is not an evidentiary hearing on the underlying merits of the claim. If it were to be such, the court should have provided us notice that it intended to combine the request for preliminary injunctive relief with a hearing on the merits. We did not do that. That's why I asked the court as to what its status was with respect to how it wants to proceed on this. The notice was for a 30-minute hearing. Clearly, it would be difficult to do a 30-minute hearing with the number of witnesses that we potentially have that include the 3 parking enforcement officers.
Let me state that my view about that is, in the absence of agreement from the defendants to this, and they're here all without counsel, that I would not move forward on offers of proof. I would want to hear evidence from witnesses.
I'm prepared to do that.
But I do preliminary. There's another issue I'd like you to address, and even though nobody has clearly briefed this yet, but the constitutional issue regarding the scope of the injunctive relief that's requested. Other than cases that you've cited talking about the court's general power to grant injunctive relief, I don't see any authority addressing you haven't cited any case where a court has granted the kind of relief that you're seeking in a situation analogous to this. And I have reviewed some decisions in other contexts where courts have expressed some concern about buffers and particularly in the abortion center context. I don't know if you've seen any of those cases.
I have, Your Honor, and I appreciate the reminder. I do have a memorandum of law or a proposed order. I wasn't sure how the court wanted to proceed at this point, but I would like to submit that to the court. I have provided a copy to the defendants.
You have given a copy
yes,
to
I
the
have, Your Honor.
defendants?
I have not
To
received
each
that.
of the defendants?
I just have handed out a copy to Garrett and give for the two of you. I have another copy for you.
Okay.
They were put on the table just a moment ago.
Let me just say, Attorney Mullins, have you given copies, because each of these defendants are parties to the case. Have you made copies for each of them?
Yes, I did, Your Honor. And I have extras if I just handed out 6 and there are 6.
And Mr. Freeman, please understand, it's just handed to you and to all the parties to the extent that the defendants want additional time to address the arguments raised in this memo. Will certainly give all parties an opportunity to address.
That's presuming we move forward, but we're still dealing with a motion to dismiss at this time, correct?
Yes, that's right.
So, Your Honor, you had started to ask me a question with respect to the underlying constitutional issue. Again, that's a little bit outside of the standing question. I did provide the court with a memorandum of law. Again, I'm going to be candid with the court. This is, as far as we can tell, a fairly unique situation within the context of government in general and the city in particular. The constitutional question arises as to whether or not the individuals are going to be impaired in their ability to either express their constitutional rights or videotape. We're suggesting to the court that neither of those happen. The principal decision in the First Circuit is the Glick decision that came out of Boston. It's cited in the memorandum of law that I provided to you. Under that decision, the First Circuit Court of Appeals concluded that where you have an individual standing from a, quote, comfortable remove, end quote, the court does not define what that is, who is simply filming, videotaping, or using a handheld camera device of some type, 2 officers in a public place that happened to be Boston Common, in an arrest, that without more, you cannot arrest that individual, you cannot interfere with their First Amendment rights. It's clear that members of the public have First Amendment rights to do that. The question becomes, where's the line with respect to that? In Glick, he was not at all doing anything with respect to the officers. We would submit to the court, and the evidence we believe will show that these individuals are engaging in a pattern of conduct going over months and months that goes beyond Glick, where they're purposely and intentionally trying to intimidate our officers into quitting, which is where the intentional tort comes in. With respect to the First Amendment question, the court is probably aware there is a decision that was issued after Glick came out of the New Hampshire District Court, Federal District Court. Garecki is the decision. I understand it's also on appeal to the First Circuit. In that decision, the Federal District Court distinguished the Glick decision. Briefly, in the facts in the Garecki decision were that it was a late night stop, individuals coming back from Concord. I believe it happened over in Ware. Presence of a gun, individual pulls up behind the car that the police officer stopped. Woman in that car gets out, confronts the police officer, starts filming and demanding to film. Police officers ask her to move. She initially refuses. You can see where this fact pattern is going. The officer calls for backup, and subsequently they do arrest the woman who was filming. Turns out she had no opportunity. There was no film that was taken, but they arrested her on various charges. I believe she did file a 1983 action after all the charges were dismissed. And the Federal District Court said no, that there was qualified immunity here, that based upon this fact pattern, the First Amendment issues, the constitutional rights were not clear. The Glick decision didn't answer that kind of fact pattern. We're here on an evolution of that fact pattern. We're here with a group of individuals that we would submit to the court are engaged in a pursuit and concerted activity with one purpose, and that's to get these individuals to quit because their stated purposes you have seen in my pleadings is that they do want to shut down the city's parking department. That's not disputed. So from the city's perspective, coming back around to the motion again, we believe that the city certainly has standing with respect to this and going forward. We also believe that from the court's perspective, it does not and should not conclude today whether or not the cause of action is something that the city wins on, only whether or not the city has a reasonable basis to proceed with that cause of action at a full-blown evidentiary hearing.
Again, we're still on the motion to dismiss. Ms. Freeman.
Despite the fact that he didn't address hardly anything in the motion to dismiss in that extended filibuster, I'd like to point out that originally when I filed this, I did cite not the U.S. Constitution as he suggests in his objection. In fact, I never mentioned the U.S. Constitution. I cited New Hampshire Constitution Article 22 about free speech and the liberty of the press being essential to the security of freedom in the state. They ought therefore to be inviolably preserved. And also Article 8 of the New Hampshire Constitution, all power residing originally in and being derived from the people, all the magistrates and officers of the government, that includes parking enforcement officers, are their substitutes and agents, and at all times accountable to them. Government, therefore, should be open, accessible, accountable, and responsive. Essentially, the argument of the city in this case is that individuals engaging in their constitutionally protected rights on public property should be somehow restricted from being within a 50-foot anti-freedom zone where they're not allowed to engage in their Article 8 right to hold these government officials accountable for their actions. The fact is, these people accepted a job position that can be a little bit difficult at times. And as you saw in their own court filing, in the parking enforcement's job descriptions on the second page in there, it actually says that these individuals are to be subjected to mental and verbal abuse. Now, I don't agree that I conducted any sort of mental or verbal abuse, and I don't believe any of these other good folks have done that. But even if I were doing that, and that's what they're alleging, they're calling it interference and harassment and all these other terms, even if that were true, it's part of their job description. They accepted this position knowing people on the streets were going to be upset at them over that. So again, I still haven't heard anything about a legal right being violated, so therefore, to me, this court can't move forward on this case. But they have not yet alleged anything about me or any of these other folks violating their legal right. I don't know what their contracts are, and I don't dispute their ability to contract with individuals, but their contracts don't override my constitutional rights.
I think in a nutshell, I think what they're arguing is that you're aware of their contractual relationship with their employees, and that your conduct is tortuously interfering with their relationship with their employees.
And that's their argument, but they don't have a right to their employees. They have an agreement with their employees to, and there's certain, as you've seen in their filing, there's certain requirements that those employees have to meet in order to be considered legitimate employees. So they have their agreement, and that's fine. That's their business. That's not my business. I didn't know what their agreement was before I got into to this, and I still don't know what their agreement is. I haven't read their contracts, and I have no interest in reading their contracts. Their contracts are their business, but ultimately, if an employee feels uncomfortable at a job due to whatever the circumstances, in this case, the circumstances are people exercising their constitutional rights to free speech, to be the free press, and to hold government bureaucrats accountable for their actions. So that, to me, has absolutely nothing to do with their contract. I don't see what the issue is here.
I think I understand the arguments. I'm going to, I'll address that separately, but since there's no request to continue the hearing, we'll proceed with that.
I would
Again,
prefer.
I'll take it under advisement.
I would prefer that you issue a ruling on that motion before this hearing continues. So if so, I'll resubmit that motion to continue.
I understand, so now you're moving to continue the hearing?
I would like to continue until you get a chance to rule on this motion to dismiss. I think this is critical because I don't want to waste any more of the court's time than necessary. Any more of these good people who have taken time out of their days to be here.
Attorney Mullins, are you opposed to the request to continue the hearing until I've ruled on the motion?
Well, Your Honor, it's sort of a Hobson's choice, it seems to me, to some extent. Mr. Freeman has submitted apparently what would otherwise be called a replication to my objection, I believe. to the motion to dismiss or otherwise. I haven't had an opportunity to review it in depth. But it's clear to me, or it seems clear to me anyway, that the court is concerned with respect to this intersection between the, as Mr. Freeman is pointing out, what he alleges to be his constitutional rights and the city's rights with respect to the protection of its contracts. That's a concern to the court. If the court is grappling with this issue to the extent the rest of us are, then I would like leave to be able to respond to whatever pleading was submitted by Mr. Freeman at this point, in order to be able to provide the court with a sufficient objection to what he may be actually alleging.
Here's where I'm going. It does seem to me that there are some preliminary threshold issues that need to be addressed, and that rather than moving forward, if there's it sounds like both sides would like the opportunity to brief these issues and to address them in a meaningful way. My inclination would not be to move forward with evidence unless that's what the parties want. But what I'm hearing is that both sides seem to agree that it makes sense that as a threshold matter, I determine whether the action can go forward.
I think that would be appropriate, Your Honor. I certainly don't want to put everybody through the city, and including the defendants. I will submit to the court and was candid right from the beginning with the court that this is one of those issues that, as far as the city can determine, this is New Hampshire, Your Honor. There's not a whole lot of law in general in New Hampshire.
That's the way we like it.
And on the other hand, they are issues that the court needs to address.
Let me say this. I think there are significant issues, and I think there are important enough issues that rather than trying to do this in a piecemeal fashion, I would prefer to have both sides, both the city and the defendants, have a meaningful opportunity to brief these issues so that, and for example, the city has today filed this memorandum of law that the defendants haven't had an opportunity to respond to.
I still don't have a copy of
it. And likewise, Mr. Freeman, I think in terms of some of the issues, some of your arguments, I think the city should have a fair opportunity to address those as well.
I would appreciate it if they actually would address it. If you look at their response to my original motion, it's like they didn't even read it.
They can respond however, both sides can respond, can address or not address whatever arguments they think are appropriate. I'm just going to give them, I'm going to give both sides an opportunity to brief the issues, and I'm wondering whether we should have, the next hearing should be, and I'm happy to do this either two ways. We can either, I can give you additional time and I can rule on the pleadings, or I can give you additional time and we'll schedule a hearing to address dispositive motions on the case, whichever the parties would prefer.
That's a term I don't understand, a dispositive motion.
Oh, motion to dismiss.
Huh.
To dismiss the case, yes.
So what were the choices again?
Your Honor, given the difficulty, I think, in the legal underpinnings to this, it seems to me that it would be necessary for the court, in order, once the matter is properly presented, I take issue with this comment that I didn't understand or respond to this motion to dismiss, and I'm sure the court recognizes and understands that. The issue from my perspective is I need to know what it is they're saying, rather than just the constitutional issue about there's no standing here. And I need to be able to, and I think it's important for the court to determine within the context of the motion to dismiss, once it's filed, my objection is there, the memorandums are there. It seems to me that it would be necessary for the court to have some evidentiary hearing with respect to that. I don't see how the court in the vacuum can make a determination of the legal issues without at least having some understanding of what the actual factual underpinnings to the arguments are.
And I would object to that in that I don't think the court can move forward without having the city claim to have a legal right violated. I mean, that's what your job is to determine whether or not a legal right was violated, and they're not even making the claim that one was. They're just claiming that we're interfering with some nebulous contract, and I'm pointing out that this is merely constitutional. Is there more that you need?
Your Honor, with all due respect, this is not a constitutional issue.
Attorney Mullins, again,
Yes,
I'll give you an opportunity to address, but
yes,
Mr. Freeman waited, and I'll give Mr. Freeman an opportunity to respond.
So you have my original motion and now the response to their objection. Is there more that you would like from me as far as a memorandum? I feel like I've outlined my position fairly.
There are really a couple of issues. more than two issues, but one issue, threshold issue, is the question of standing, and that's an issue that I think if either side wants to submit, I'll give both sides additional time to submit pleadings on that issue, but I think both sides have submitted pleadings on that issue. The second issue, let me just finish. The second issue is this question of the constitutional issues, and although you've alluded to it in some of your arguments, Mr. Freeman, you haven't moved directly on the question. You haven't said, in effect, that you haven't made a direct constitutional claim. And I take it that the petitioner has filed a memorandum of law. And again, it was just handed to me today as well. But I think what would be helpful to the court is if the parties, to the extent there are arguments on the constitutional issues, legal arguments, that those are made. And Attorney Mullins, I don't know if you address those in your pleading.
Only tangentially, Your Honor, because as you pointed out, they were not directly asserted within the underlying context. So we will make a more direct effort.
Let me suggest this, that what I think makes sense is to give both sides an additional time period. I'm thinking the order of either 10 or 20 days, whichever the parties think it would be an adequate time to address these. These are, I don't mean to make light of these are serious, difficult issues that take time to analyze.
Many of us will be out of town over the next couple of weeks, so certainly 20 would be preferable.
I prefer 20 days.
Okay, so what we'll do is I'll give both sides an additional 20 days to submit whatever. I mean, both sides. I mean, I don't mean to suggest by this that only Mr. Freeman can respond. If any of the other defendants want to submit a legal memoranda addressing these issues, certainly Mr. Freeman doesn't represent you. You're here all representing yourselves. You're free to file anything that you want addressing those two issues. But it seems to me that those two threshold issues need to be addressed. And what I think we'll do is we'll set it up for, I'll tell you, Mr. Freeman, on the standing issue, I'm inclined to think the city has the better position on that issue. So I haven't yet determined it, but what I'm going to do is schedule this for an evidentiary hearing. I know 30 minutes was not adequate, but assuming I deny the motions to dismiss, and certainly if I grant the motions to dismiss, the case is over. Unless the city wants to appeal my decision to the New Hampshire Supreme Court. But if I deny the motions to dismiss, how much time are you going to need for an evidentiary hearing?
I think it would be fair to say, given the number of defendants who will probably want to speak whatever witnesses they have, this is easily going to take a full day. I have 3 witnesses, the parking enforcement officers. To the extent that the court needs to hear testimony with respect to the creation of some of the evidence that we have, I've got at least 5 witnesses.
And again, Mr. Freeman, I know you've been sort of the designated person who's speaking.
I just stood up, that's all. No one designated me to do anything.
So you tell me, and if anybody disagrees with what you're saying or wants to offer, do you think a day is adequate?
Sounds right to me. I mean, I'd rather be doing productive things, but this is their gig. Just to clarify what you were saying before about the arguments for regarding the Constitution, that's not in regards to the motion to dismiss. That's something separate.
Well, it's one of the issues that in doing some analysis in preparation for the hearing that I've come across in some cases that talk about the scope of requests for injunctive relief and questions raised about whether constitutional rights, First Amendment rights are violated by certain kinds of those requests for injunctive relief. So I think to the extent any of the parties have legal arguments that go to that issue, it would be helpful to the court if those could be submitted. If you think that those provide a basis for a motion to dismiss, or if you just want to address any legal arguments made by the city, I'm going to give both sides 20 days to file additional memoranda of law on those issues.
Yes, Your Honor, I do have a clarification question on the standing question.
Yes.
Because it appeared to me that Mr. Freeman, especially in his initial pleading, was arguing somehow that standing was falling under the New Hampshire Constitution, that somehow there was no constitutional right to standing. The question that we looked at it was that the city has statutory rights with respect to how we can proceed on contract issues. It's a little unclear to me where the court is looking at the question with respect to standing. Are you looking at it from statutory authority provision with respect to for the city?
I am just looking at precedent from the New Hampshire Supreme Court on the question of standing, when parties appropriately have standing. And as I've indicated, my inclination, although I haven't ruled on it, that's why I want to give everybody another 20 days to submit whatever memoranda they want. My inclination is to deny the motion to dismiss based on standing, but...
Will you give a written explanation as to why? Because I would like to know what their legal right is that they're alleging has been violated, which I've yet to hear.
I'll issue a written decision on the motion, and I'll give, my order today will be that I'm going to give all parties an additional 20 days to submit whatever legal memoranda they want on the issues before the court, and we'll schedule a full-day evidentiary hearing as the docket allows after those 20 days. Anything further today?
So just to clarify, 20 days to put in further memos regarding motion to dismiss / constitutional issues. You'll then rule on the motion to dismiss, and upon that ruling, set a date for the evidentiary hearing?
Because the way the docket works, in all likelihood, we'll set a date probably at some point in the next week or so on the hearing. It'll be set for after those 20 days, and if you're at all familiar with the docket in this court, finding a full day for an evidentiary hearing, it's not likely to happen in the month of June.
Well, Your Honor,
or in early August. We have 2 weeks of jury trials set for July. And obviously many of those cases involve criminal defendants who are incarcerated, and those will take priority. So I can't tell you when that will be scheduled, but it will be scheduled for some date after those 20 days.
Your Honor, is it possible to work with the clerk's office? I mean, I'm saying a full day because out of caution, as you know, these matters, I mean, we're here at 3:11 in the afternoon at this point. Is it possible to work with the clerk's office and see if there's a determination, maybe we can be a backup, or if I can narrow down the amount of time, or we can narrow down the amount of time that's necessary?
Let me say, I'm always interested in thoughts about narrowing down time. If the parties can do that, it may be that it has to happen over the course of, we do an afternoon one day and come back and finish on a morning. It might not be one calendar day. It'll just have to be scheduled as the docket allows. But I think what I'm hearing is that the parties think that if it does, we do have an evidentiary hearing, that there seems to be a sense that a day would be necessary in order to complete it. And I'm hearing that from both parties. Mr. Iyer, if you want to address the court.
Yeah, I'd just like to add, I'd like to remind, Mr. Mullins said that we're at a nexus or intersection. I think this is a juxtaposition, what's alleged versus what's actually been done. The fact that I'm included in this injunction at all, I'm not partaking in any of these activities, just speaks to me about the frivolous nature of it. And I just wanted to remind everybody that everybody over here is being paid right now by taxpayers in Keene, and we're taking time out of our lives. Some of us had to come to town from outside, so I just wanted to say, to continue these hearings, months out, multiple times. If you read what I've written, you should just say, okay, this is without merit. I guess I take issue too with being, lumped in collectively. This is how my name was somehow brought into this situation, and to continue to be told to come to this courtroom seems pretty ludicrous to me.
Well, let me just address that too, Attorney Mullins, just so the city's aware that the case was filed against 6 individuals. If we proceed to an evidentiary hearing, I would expect the city's presentation to address each individual and what evidence it has to support the claims against each individual. And I do note that some of the allegations in the affidavits are not specific as to individuals, but talk about them collectively.
Yes, I understand that, Your Honor, and each one of the parking enforcement officers will clearly identify each one of the individuals and events that may have occurred. The city, quite candidly, is also considering filing a motion to amend. I think we'll wait and see what happens, what the court does with the motion to dismiss, because in reading it at this point, it's not clear. The intention was to make sure that the court understood that this was not just a group of individuals, but it was a collective group acting in concert. So we may be filing a motion to amend the pleadings just to make sure that that issue is squarely before the court.
I object to the idea that anybody's a collective. We're all individuals, and we all have our individual motivations. There's a point to the idea of scheduling that I wanted to put out there. And I think Garrett can probably speak to this a little bit better. It's my understanding that Tom Mullins here has refused to negotiate when Garrett attempted to
Objection, Your Honor. Anything that we talk about is part of the...
Issues involving negotiation or settlement are not properly before the court.
What I mean is, I think they brought this case in bad faith with that.
Objection, Your Honor. This objection, Your Honor?
Well, let me hear them out, then I'll hear your
In that
objection.
they did not take the time to approach any of us and discuss these matters prior to bringing them before the court and asking for your time. And when asked to negotiate, and Garrett, you were the one that had the conversation, they didn't want to talk about it. They said maybe later we'll talk about it. So we may not even need to be here today had there been some level of negotiations going on before the court.
Well, let me just say again in terms that I understand your position that that's the extent that parties have settlement discussions. It's a separate issue. If the parties are able to work things out with the city in a way that's acceptable to everyone, that's a separate issue. But as I've said, the schedule will be the one that we've discussed. That all parties will have an additional 20 days to submit whatever legal memorandum they want on the issue before the court, including the motion to dismiss, and we'll set up a one-day evidentiary hearing after that, and the hearing, if I grant the motion to dismiss, the hearing will be canceled, obviously. Anything further from the parties today?
Yes, regarding the motion on the behavior of the bailiffs at this court, which I presume you've had a chance to read that.
Let me cut to the chase on that one. What I've done on that one is I've said that we're going to give 10 days for the plaintiffs to respond to your motion, and I'll have a separate hearing.
Right, I wanted to
before the
address
court on
the
that
date
issue.
of that hearing. I have another hearing at district court on that same day, that same morning.
And it hasn't been set for a hearing already?
Yes. Let me see.
Oh, I see.
24th.
Okay.
At 9 a.m. So if the 24th is okay with me, but maybe if it could be moved in the afternoon, if there's time for it in the afternoon, that would be preferable.
Attorney Mullins, do you have any position on the timing of the hearing on the motion? Really, it's you don't need to take any position.
I was going to say, Your Honor, I don't have a dog in that fight, so.
Do you? But in terms of the timing, Mr. Freeman's asking that hearing be moved to the afternoon. Do you have any objection to that request? Do any of the other defendants have any objection to the request that hearing be moved to the afternoon on the 24th?
I have a quick question. Do we all have to show up to that hearing?
Yeah, my question.
I think this is Mr. Freeman's motion. I think that if none of the other defendants want to appear, or if any of them, you're certainly free to come. You're welcome to be here, but there's no requirement that you be here for that hearing if you don't want to be here.
Thank you.
But Attorney Mullins, I would appreciate the city being here.
The city will be here, Your Honor. Just don't expect the city to be too participatory.
I understand. Anything further this afternoon?
Question, will I be able to have Kyle Jarvis talk about his experience, even though he's not involved in the case with...
That will be between you and this gets into clash of different media rights, whether or not another reporter wants to be called to testify.
If he's willing to testify, would he be able to during that hearing?
We'll address it at the time of that hearing. I think my intent was just to have argument only, because I know you raised some issues about the scope of certain court orders.
Would I be able to submit, if he were willing to write up an affidavit of his experience? Because I gave my experience of observing what happened. If he would give his experience, would I be able to submit that into that discussion?
we'll take that up at the time of that hearing. Okay, thank you. Anything further?
Oh,
Ms. Mack? Okay.
Will there be another order sent out on the timing for the 24th?
Yes, yes, I'll make sure that there's no objection from the city, and my only question with the timing is what else we have scheduled for that afternoon. So if we have a full afternoon, it may be moved to another date, but there's been no objection to move it from the morning. Thank you, Mr. Reed.
I would ask about if I wanted to reassert what I've already asserted in my response to the petitioner's injunction, it sounds like constitutional issues are being brought up now, that we should address the constitutional issues as well, because I did not address them in my
Let me
response.
say, nobody needs to file anything further. I'm just giving all parties, in light of the issues that we were discussing this afternoon, I'm giving all parties an additional 20 days. You're not under any obligation to file anything further, but I'm giving you another 20 days if you should want to. Thank you all.
Thank you.
All right.
Please.
See you in a few weeks.
We'd like to invite you to visit freekeen.com. Freekeen.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeen.com also has comments and discussion forums so you can be heard. Freekeen.com.
I should be in Keene, New Hampshire with the Free Staters.